My name is Troy McKenzie, and it is my pleasure to lead today's discussion. The topic for today's panel is the Supreme Court, or presentation is the Supreme Court in American Life, Continuity or Disruption in the Law. Before we get started, first, let me say a bit of welcome on behalf of the Law Alumni Association, which is sponsoring this online CLE course. And a special welcome to all of those NYU School of Law alumni who are celebrating their reunion this weekend. I wanted to talk today about the Supreme Court, a topic of universal interest most times, a topic that some might say is over-examined. And my approach today is going to be a little bit different. I'd like to talk about the court as a new court whenever a new justice arrives. And my thinking on this topic really was sparked by teaching a seminar on the Supreme Court for the last several years. Beginning in 2017, when I came back from a public service leave in government, I thought I should teach a seminar on the Supreme Court, which had been taught in previous years by two of my colleagues. And I thought I could launch into my usual discussion as a law professor. Law professors, we sort of can talk about anything. And then I quickly realized that the court that I knew when I was a law clerk 20 years ago now did not exist anymore. As Justice White famously said, every new appointment to the court means a new court. Every new justice transforms the court in a particular way. So I decided that the way to teach that class was to have a more recent law clerk from the court, someone who was in practice or in academia who knew the court and knew the current justices as a way of balancing out my more historical knowledge of what the court was 20 years ago, and my more academic knowledge reading the work product of the justices in a sort of doctrinal manner. And it turns out that that was a very good way to teach the course because it led me to understand the differences among the justices, even those justices who, broadly speaking, are part of the majority coalition on the court right now. Right now, of the 9 justices, 6 were appointed by Republican presidents, 3 by Democratic presidents. In the past, that was not necessarily an indicator of ideology or even an indicator of general mood about important constitutional questions. Justices tended not to follow anything that might look like a sort of a strict party confines. But as the view of judicial appointments has changed in both parties, one might say that that has also changed the nature of the appointment process to the court. But if you look at the majority coalition, and by that I mean the Chief Justice, John Roberts, Justice Clarence Thomas, Justice Sam Alito, Justice Kavanaugh, Justice Gorsuch, and Justice Barrett, you see that there are some real divergences among them in important ways. And this is not new. If you go back to the court of the New Deal era, FDR appointed almost the entire court by the time he died in 1945. And nevertheless, that court, justices almost all appointed by the same president, justices who were broadly speaking New Deal liberals, ended up having vehement disagreements with each other. And why is that? Well, one reason is that justices who share similar views on important legal questions of the day might end up diverging when the legal questions change from day to day. And the other is that justices, even justices who are of like mind in many ways, have different methodologies they follow and also different judicial temperaments, sometimes also different personal temperaments. And each of these can bring out conflicts and divergences within a coalition. So if we take a snapshot of the court as it stands today, if you look at the majority coalition on the court, broadly speaking, the dominant methodology of interpreting statutes and the Constitution is textualism and also originalism. Textualism meaning that the text of a statute is what should control, not a broader investigation of purpose based on materials external to the text. And originalism, meaning that both for the Constitution and for statutes, the way in which one should understand text is by investigating the original public meaning of the text itself, not an individual framers or statutes sponsors view of what should happen when a statute is adopted or once the Constitution was adopted. So in a court where the justices, broadly speaking, share, in the majority coalition, broadly speaking, share the same methodology, take a case like Bostock against Clayton County, which is the landmark decision from a couple terms ago in which the court decided in a 6-3 vote that sexual orientation discrimination or discrimination based on sexual orientation is actionable as discrimination, quote, because of sex, end quote, under Title VII of the Civil Rights Act of 1964. Now, what was interesting about Bostock is that the author of the majority's opinion was Justice Neil Gorsuch, appointed by President Donald Trump, an originalist and a textualist, and it is a textualist opinion. It simply reads that phrase because of sex, thinks about the meaning of the words, not the grander purpose of the statute in 1964, and then logically concludes that discrimination based on sexual orientation is in fact discrimination based on sex. But there are dissenting votes in that case. You have Justice Alito joined by Justice Clarence Thomas dissenting, as well as Justice Kavanaugh dissenting. And certainly Justice Thomas and to a lesser extent Justice Kavanaugh would consider themselves a textualist and originalist. And nevertheless, even though broadly speaking, they may share the same methodology as Justice Gorsuch, it's not the same methodology. As applied in this context to this statute, you see a divergence in outcome, even with justices appointed within the same majority coalition, who broadly speaking have the same general view of how the law should be interpreted. And that is what gives a sense of interest and anticipation to the court in the future. So the other area of interest is direction and speed of change at the court. Even when justices may, broadly speaking, agree with the direction in which the law should be nudged or shoved, they may not necessarily agree on the speed of change. And a perfect example is a case from last term, Fulton against the city of Philadelphia. Fulton is a case that, when it got to the court, looked as though it might lead to the court's overruling of a major precedent from about 30 years ago, Employment Division against Smith. And for those who didn't follow Fulton when it was before the court, I'll very briefly explain the question presented in the case. In Fulton, the city of Philadelphia had refused to renew a contract with Catholic Social Services, an organization in the city affiliated with the Catholic Church. The city's contract provided for various organizations to facilitate foster care services. And the city said that unless Catholic Social Services agreed to certify same-sex couples as foster parents, if eligible under the criteria set by the city, then they would not be allowed to be part of the city's contract for those foster care services. Catholic Social Services alleged that this was a violation of the Free Exercise Clause of the First Amendment. And a unanimous court ultimately agreed with Catholic Social Services, but in a group of opinions that showed a very stark disagreement among the justices and within that majority coalition, not so much about what the bottom line answer was, but how to get there and how quickly to get there. Chief Justice John Roberts wrote the majority opinion. His majority opinion applies that older precedent I mentioned, Employment Division against Smith, and found that under Smith, the city had violated the Free Exercise Clause. Now, this is a little puzzling if you know something about Smith. Smith was a closely divided case in which a majority opinion by Justice Antonin Scalia held that there is no free exercise claim by someone who alleges that the government, in applying a neutral, generally applicable law, has thereby caused an inability of the plaintiff to exercise a religious activity or position. In Smith, the plaintiffs alleged that they were part of a church in which the taking of hallucinogens was sacred. No question about the sincerity of their views. And nevertheless, the Supreme Court said the government prohibition in question, which essentially provided that you would not get unemployment benefits if you were fired for having taken drugs, that was general and neutrally applied, and it did not require that the government carve out an exception for those who had a sincerely held religious belief contrary to that neutral and generally applied requirement of law. In Fulton, the Chief Justice writes an opinion saying, well, actually, what the city of Philadelphia did was not neutral in terms of its religious implications, and it was not generally applied because the city had a number of exceptions. There was a sort of a freedom of a decision maker to make exceptions to the rule. So that was the majority, the opinion for the court by the Chief Justice, applying Smith, expanding an exception within Smith in order to find a free exercise violation. But then three justices, Justice Alito, Justice Thomas, and Justice Gorsuch, went further and said, maybe we should simply overrule Smith, and we should use heightened scrutiny when considering a free exercise claim and spelling out all of the perceived deficiencies in Smith over the last 30 years. I think the key opinion in that case, however, is an opinion, a concurring opinion by Justice Amy Coney Barrett. And Justice Barrett lays out many of those same concerns about Smith, but then pauses and says, well, if we overturn Smith, what follows next? What exactly is the right test? What are the consequences of overturning Smith? And so her opinion suggests that even though she may be sympathetic with Justices Alito, Thomas, and Gorsuch as to the ultimate direction in which the law should move, she's uncomfortable moving there until she knows exactly what the full implications will be. What exactly is the test that will follow if Smith falls? Contrast that temperament with Justice Gorsuch's temperament in the Ford Motor personal jurisdiction case from last term. For those of you civil procedure gurus, you will know that Ford Motor reaffirmed the position that specific personal jurisdiction is appropriate in the place of injury if there are sufficient minimum contacts by a defendant with the forum, and the claim relates to or arises out of the defendant's contacts with that particular forum. Justice Elena Kagan wrote the opinion. There's no disagreement among the justices, again, about the bottom line. Everyone was comfortable with finding that there was personal jurisdiction over Ford, the defendant. The majority opinion by Justice Kagan simply applies existing case law, makes some clarifications, expands perhaps a little bit on what the due process clause requires under the circumstances. Justice Gorsuch writes an opinion concurring in the judgment in which he says, all of this case law we have built up for the last 70 or 80 years that we call personal jurisdiction doctrine, I'm not sure it's right. Maybe it is, maybe it isn't, but I can't really say that it follows if one applies an originalist methodology. And so Justice Gorsuch suggests that we start from scratch, start over again, and explicitly says he doesn't know and isn't that concerned about the potential that by starting afresh, the consequences might be unexpected. Maybe the result will be better for defendants, or maybe it'll be worse for defendants. That doesn't bother him at all. So again, you have two justices appointed by the same president, broadly speaking, who profess similar approaches to interpretation, but who have very different temperaments about the speed of change and whether or not the court should jump or take baby steps in the same direction. So that's a sort of background for where the court is now. I wanted to talk in somewhat more detail about emerging themes at the court, the new court that exists today. In terms of the docket of the court, the types of cases that seem to be drawing the attention of the justices, and also in terms of the procedural steps that the justices have employed in order to build their docket. A quick note about the court's docket. The court today has a docket that is far lighter than the court a generation ago, even the court 20 years ago. If you take a snapshot of the Supreme Court circa 1982, 1985, the court routinely heard and decided anywhere between 140 and 160 cases per term. It was a very busy court with justices who were deciding a lot of cases. When I clerked at the court about 20 years ago, that was down to about 90 cases a term. And there was discussion in academic circles and outside academic circles about why the court seemed to have such a light docket. Today, the court is lucky if it gets to 70 cases per term, decided after full briefing and argument. And in recent terms, partly driven by the COVID pandemic, the court has been in the sort of 50 to 60 range in terms of cases decided after full briefing and argument. Now that leads to a couple consequences. One is the justices have more capacity to linger on cases longer, to write longer opinions, to write more separate opinions. The other is that the justices also have more capacity to move on cases before full briefing and argument. And so I want to talk a little bit about one procedural aspect of the court's docket, and that is the rise of the so-called shadow docket at the court. By shadow docket, I simply mean those decisions by the court in a variety of matters in which the court does not have full briefing and full argument on the merits before its decision. There is nothing new about the shadow docket. The court has always had a docket of, say, emergency applications in pending death penalty cases. When there are pressing issues that come up from the lower courts, the court has always had this separate area of its docket where there isn't full briefing, full argument on the merits. The term shadow docket, however, actually comes out of a conference held at NYU several years ago, in which Professor Will Baude from the University of Chicago Law School wrote a piece that was mildly critical of the court's use of its emergency docket. in order to decide what he considered important questions that probably should have been decided after full briefing and argument on the merits. And Professor Bode talked about the shadow docket, sort of named it and claimed it. That has now led to a little bit of a cottage industry of commentators who are critical of the court's use of its powers to decide cases in that way, particularly during the Trump administration and then again during this administration. For example, hearing an emergency stay before there is a final decision on the merits in the court below and the like. Some justices bristle at that term. Justice Alito, for example, has publicly criticized references to the shadow docket. And Justice Kavanaugh, in a separate opinion in a case, criticized a colleague for making reference to the shadow docket. I'm not sure why the justices are so sensitive to this criticism, because again, there is nothing new about this side of the court's docket. What may be new is the court's increased capacity to spend time on these preliminary matters and turn them into more full matters. The court might be moving, however, to something of a compromise, and I want to highlight the vaccine mandate case, NFIB against OSHA. This was the case in which the court granted a stay and effectively blocked OSHA, Occupational Safety and Health Administration, from enforcing a requirement that in workplaces of a particular size, employees be required to be vaccinated. Without getting into the merits of that case, what's interesting about it is that it came up on the shadow docket, and the justices decided to hold argument, have briefing on the emergency application, and then hold argument before deciding it. And perhaps that will be the way the court responds to criticism of the rise of the shadow docket, which is to create this mezzanine category between those types of applications that are simply dealt with on the papers and full briefing and argument on the merits, where these types of applications are subject to briefing and argument, but technically do not finally resolve the case because they are in an interlocutory posture rather than after a final judgment. And it's unclear whether the court will do more of this, but it is a very unusual development. I mean, this is not something the Supreme Court has done at all, except in rare cases where there was something of national importance that required that type of sort of special argument. But there are hints in the NFIB against OSHA case that the court will do this more frequently if it decides, for example, to issue an emergency stay of an agency's decision-making, or if the court decides that it wants to reverse some interlocutory decision by a court of appeals. Perhaps the court will not do this argument approach or take this argument approach because it's too disruptive, but it is something new that may be a model for the future. So I want to talk a little bit about some of the areas of the docket that seem to be drawing the justices' attention today. Probably the number one area to highlight is the First Amendment in multiple buckets. The religion clauses of the First Amendment, these are the clauses the justices seem to have the greatest intellectual interest in bringing onto the docket and developing. I already mentioned the Fulton case. The justices are having a conversation among themselves about exactly how the Free Exercise Clause should be applied. They are also in the process of potentially changing the Establishment Clause jurisprudence of the court. There are two important cases, one which was recently argued involving a coach who would pray in the middle of a football field, high school coach, and also a case from Maine regarding whether or not the state of Maine must give to schools that are quote unquote sectarian, meaning schools that are religious in their not necessarily institutional affiliation alone, but also in the type of education they provide, whether Maine must support those schools if Maine is providing support to non-public schools that are not sectarian in nature. That case, which has not gotten as much attention as one might think, might be a significant case, because if the court finds that the free exercise clause requires the state to provide that funding, or if the court decides that some blend of free exercise and establishment clause principles require it, that could be a fundamental shift in many areas where the governing law has long held that government may support, but is not required to support religious institutions in particular functions. The other area of First Amendment interest is speech. Now, one thing that's interesting about the court today with respect to First Amendment speech is that it was assumed until relatively recently that the court, regardless of the shifts in ideology and methodology of the justices, would remain committed to robust, almost absolutist protections of speech. The court of the late 1980s and 1990s coalesced around a number of principles that meant that the First Amendment speech clause was something that justices across the spectrum agreed required strict support, enforcement, and pretty much consistently from the Rehnquist court to the Roberts court, the Supreme Court would enforce free speech claims without much dissension. And this was something of a surprise because the court in the 1960s, 1970s had been deeply divided on the ability of government, for example, to regulate speech. Not just speech that was the most sensitive, the core of free speech, political speech, but also commercial speech. The Rehnquist court, the late Burger court, the Rehnquist court, and the early Roberts court seem to be very similar in their approaches to free exercise principles. But something is happening on the court today that suggests that there is, in fact, a potential change coming. And I wanted to suggest two areas of movement away from that type of strong, again, almost absolutist protection in speech cases. One of them is that justices, at least two justices, have indicated openness to overturning New York Times against Sullivan or heavily qualifying New York Times against Sullivan. Sullivan, of course, is the case that imposed First Amendment protections with respect to the state's tort law of defamation, particularly for public figures. And Sullivan makes it difficult for a public figure to sue on a defamation claim by constitutionalizing effectively that slice of state tort law. Justice Thomas, Justice Gorsuch have each suggested that originalism principles do not necessarily support the rule that came out of Sullivan, which was a Warren Court era decision that until recently had not been questioned at all by any justices. And surprisingly, there's also some sense of confusion, discussion about how to apply the principle that government cannot regulate speech content unless the regulation satisfies heightened scrutiny, strict scrutiny. Just, I guess, about 6 or 7 years ago, the court decided a case called Reed against Town of Gilbert, which had language in it that suggested that any regulation of content that required one to read the material in order to determine whether or not the regulation applied was subject to heightened scrutiny. Recently, in a case coming out of the city of Austin, the court seems to have retreated from that a little bit. It's a closely divided decision, but the court has softened some of the language that it had seemed comfortable with just a few terms ago. Now, I don't know if that means there will be a new coherent view of the First Amendment free speech clause, or if what will end up happening is a fracturing of free speech doctrine, so that you will have to look very carefully, case by case, context by context, in order to know whether the court is going to look with skepticism or with deference on a regulation that is purported to regulate speech. But the key players here really are Justices Gorsuch and Thomas, because if they develop a new originalist approach to the free speech clause, conceivably that would permit government to regulate speech much more robustly. The argument would be that at the time of the founding, or perhaps at the time of the adoption of the 14th Amendment in 1868, government had far greater understood powers to regulate speech. And so the text of the First Amendment or the 14th Amendment incorporating the First Amendment have to be read in light of that reality at the time. Two other areas to highlight briefly. One is administrative law and the administrative state, an ongoing conversation among justices about the non-delegation doctrine, which has essentially been dead since the New Deal, has tried to rise from the dead a couple times, but hasn't been able to do it. The court seems to have some strong interest in thinking about maybe not a complete revival of the robust non-delegation doctrine of the sort of pre-New Deal era, but something softer but broader than what current doctrine would hold. Related to that is the court's increased reliance on the so-called major questions doctrine. Now, under the major questions doctrine, the court will interpret a statute granting an agency the responsibility to administer a statutory scheme, and interpret it in such a way that even if the text of the grant of authority might capture what the agency regulation is doing, the court will think about whether Congress truly wanted to delegate that authority to the agency. And that if the area is one that presents a major question, then the presumption must be that Congress did not really intend to delegate that authority to the agency. That doctrine, a great example of that doctrine is the Brown and Williamson case. This is a tobacco case from about 20 plus years ago, in which the court held that even though the FDA had a statutory grant of authority to regulate drugs, that grant of authority did not include the ability to regulate tobacco. And the court gave a number of reasons, historical reasons why it thought that Congress, even though giving the FDA a very broad textual grant of regulatory power, never intended to include the ability to regulate tobacco in the way the agency was trying to do. The case this term that probably presents the greatest opportunity for the court to expand the major questions doctrine is West Virginia against the Environmental Protection Agency. This is a very complicated case, complicated under the Administrative Procedure Act, but also complicated because it's not entirely clear whether the court could apply the major questions doctrine in a clean way or would have to elaborate on it. Very briefly, in the West Virginia case, the question is whether the Trump administration's rule, which purported to replace an Obama administration clean power plan meant to reduce emissions, whether that Trump plan is one that the DC Circuit properly quashed. The underlying argument by the state of West Virginia and by others on that side of the case is that the proposed alternative from the Obama administration would cause such tremendous change in the economy and to the energy industry that Congress could not have intended to give the EPA that authority to regulate. And if you listen to the oral argument in the case, I would actually encourage you to listen to the oral argument in the case. You can see how confused the justices are about exactly what the question is in the case, whether or not this is a case that truly presents a major questions doctrine problem, and also whether or not the major questions doctrine means that the agency must show that Congress thought about the potential consequences of the delegation of authority, or whether the only showing must be that Congress intended the agency to regulate the area. And so long as the agency regulates in that area properly, the sort of broader consequences are left to the normal process of administrative rulemaking. So that case may end up giving some guidance about how the court views the regulatory state, the administrative law and regulatory state structures that have been, for the most part, stable for much of the last 80 years. I also wanted to highlight reproductive rights. This term, the court has before it the Dobbs case coming out of Mississippi, in which the state of Mississippi before the court presses a very straightforward question, essentially overruling Planned Parenthood against Casey. Dobbs is an odd case in some ways, because although the question is a very clean question, the implications of the question would be conceivably that states would have effectively unlimited ability to regulate or ban abortions. The argument in the case was, again, confused. Mississippi went to the court with a very clean question, pressed it, and nevertheless didn't quite seem to give the court comfort about exactly what the state wanted. The state's brief had lots of discussion about why it would be reasonable to view abortion as morally problematic, as a public policy matter, but it's not clear from the way the court approached the case exactly how the justices will view the case. Will it be viewed as a case where once and for all, the question whether the Constitution protects a right to abortion will be resolved with an answer of no, or whether instead the court will find some way, maybe a narrow majority or plurality, find some way to cut back on the protections under current law, meaning Planned Parenthood against Casey. One other case to mention in this area is the Texas Senate Bill 8 case, Whole Women's Health against Jackson. This is another case that the court decided in a sort of emergency posture. They granted certiorari before judgment, took the case and rejected a challenge to the Texas SB 8 statute, which is a statute that makes it very difficult for someone to sue any state official in order to enjoin the law itself, which limits abortion. I think I said two more. The other area is criminal law and criminal procedure. Just very briefly on this area. This is an area where the court, in the Rehnquist years and the Berger years, tended to be quite favorable to prosecution and not to defendants, criminal defendants. The usual story I would tell anyone who wanted to hear how the court resolved criminal procedure cases, at least until relatively recently, was there were two rules. The first rule was there were no rules. Everything was a full context, all facts and circumstances. That was rule number one. And then rule number two was, notwithstanding rule number one, rule number two was defendant is probably going to lose. if there's a search issue, if there's an issue about whether something constitutes a seizure, the court was not that interested in bright line rules, but was also not very sympathetic to criminal defendants. That has changed somewhat. The current majority on the court, in a kind of cross ideological spectrum coalition, is quite skeptical of government, at least in some Fourth Amendment contexts, especially when there is new technology. The use of, for example, a GPS device in order to track somebody's car. The use of tracking when someone's cell phone pings off of a cell tower and the like. The court is also surprisingly skeptical of federal government criminal law expansion. The number of cases the court has taken involving the ACCA, the Armed Career Criminals Act, is remarkable. And almost every time the court takes one of those cases, the court rules against the government and finds that the defendant does not fit the statute. In fact, the court just decided one of those cases where the question is whether or not the defendant, who had broken into a storage facility and then had broken into 10 individual storage lockers, whether that was a single occasion or whether it was multiple occasions. And the court ended up ruling in favor of the defendant, and therefore the defendant avoided much more severe punishment under federal law. I want to close because I do see some questions in the Q&A box that I want to answer. And that's about the court and politics. This is always a sensitive topic to talk about because justices, I think rightly so, emphasize that they are not politicians. They don't see themselves as playing a political role. But I think it's important to mention politics in a different way, not necessarily partisan politics or ideological politics, but what Professor Jack Balkin of Yale Law School calls high politics, which is to say the court's role as part of government decision-making more broadly, which the court can't avoid because the court shouldn't avoid it. And what's unclear to me in the future, in light of the current alignment of the court, is how the court deals with the high politics of interbranch conflict, how the court deals with the high politics of federalism, federal-state relations, where the court will be called on as a brake or accelerator when deciding how much or how little power the federal government has in relation to the states and vice versa. And also the role the court plays as, to some extent, supervisor of the lower federal courts. So very briefly, traditionally, the other branches do not confront the court frequently or successfully, other than Thomas Jefferson's Democratic Republicans, going after the court after the election of 1800. There are very rare occasions when the political branches successfully confront the court. There were attempts in the 1960s, 70s, and 80s to strip the court's jurisdiction on a number of issues. Almost all of those failed. There was certainly FDR's attempt in the New Deal era to change the court by getting the power to appoint a number of new justices. The political difficulties and the practical difficulties of making those changes real and permanent means they almost fail. But we might be entering into an era where the political branches are consistently aligned in a way that is different from the court for a long period of time. And if that happens, then one question is whether the court will want to be in confrontation with political branches or will find ways of avoiding confrontation. The court has almost total control of its docket, so it's not that hard if it wants to avoid that confrontation. One possibility is what one might call a containment possibility, where the political branches decide to starve the court of opportunities to confront the political branches or disagree with the political branches, trying to take cases out of the court system, settling, avoiding things that might generate litigation. finding ways of using other mechanisms for as policy levers that are unlikely to give rise to litigation because, for example, maybe no one will have standing. Using areas in which the court has historically been comfortable with some limitations on its own ability to have a say. For example, some of the appellate limitations on what cases go to the court and what cases don't go to the court, or the way in which the cases go to the court. More puzzling to me, though, is the court's view of federalism. When Chief Justice Rehnquist was in the center seat, he cared a lot about federalism and tended to be skeptical of federal government and federal courts intervening in ways that limited the ability of the states to have a lot of play in the joints. Probably the hallmark of the Rehnquist court was sovereign immunity, the court's robust protection for states against suits by private individuals in federal or state court. In fact, much of that doctrine, not necessarily driven by a textualist or originalist reading of the Constitution. When Chief Justice Roberts became chief, somewhat to the surprise of some commentators, certainly to my surprise, there wasn't much of a revival or extension of the Rehnquist court's interest in federalism. But perhaps that is changing. And maybe the court will pick up where the Rehnquist court left off. Not that long ago, the court overturned a case from the 1970s that had held that a state can sue another state in its own state courts, and really without much blinking an eye in doing that, on the grounds that this sort of violated the understood structure of our constitutional system. And there may be examples where the court ends up limiting the power of some states and empowering other states, or empowering some functions by states but not others. Two very brief examples this term. A case out of Kentucky, the Cameron case, in which the court held that the elected Attorney General of Kentucky could intervene in a case to take a litigation position that was different from the position of the governor of the state. Not a shocking case in some ways, but a case that allows greater state litigation ability to use the courts as a forum for contesting important policy matters. That was a case involving access to abortion. A case out of the Ninth Circuit, Arizona against City of San Francisco, where the court is deciding whether to allow a state to intervene in the Court of Appeals in order to maintain a challenge defend rather against a challenge to an immigration policy by the Trump administration, which the Biden administration had indicated it was no longer willing to defend. The outcome of that case may be a game changer, because it would suggest that states are empowered not just within their own sphere, but also as litigators stepping into the shoes where the federal government's litigator, the Attorney General, decides not to take a particular position or not to contest or litigate in the first instance on behalf of the United States. Let me stop there, because I realize I don't have that much time and I wanted to respond to some of the questions. One question is, do you think Chief Justice Roberts can move the rest of the court to assist in keeping the court as somewhat neutral as an institutional entity? Chief Justice Roberts cares a lot about the institutional integrity of the court. He also cares about the court's ability to be perceived as not political, not in a partisan way, and in fact has used his vote at times against what he probably thinks is the answer closest to his own views in order to protect that legitimacy. One example is probably the Obamacare litigation, in which the Chief Justice voted to uphold the statute in ways that did not please many of those who were probably closest to him as a jurisprudential matter. Another example is a case out of Louisiana several years ago, June Medical, in which Roberts voted with other justices appointed by Democratic presidents, in order to strike down a Louisiana statute regulating abortion, on the ground that the statute was essentially identical to a Texas statute that the court had struck down at a time when Justice Kennedy was on the court. Roberts had not agreed with the decision in the Texas case, and yet in the Louisiana case, he said, sort of as an institutional matter, the court has decided this question, and I'm going to go ahead and go along with what the court has decided, with some qualifications and the like. The difficulty is you need to be able to count to 5 in order to have that type of control. And right now, it's not clear whether, even if the Chief Justice decides to be a counterbalance to rapid change or change away from the status quo of the court, he can muster 4 other colleagues to get behind him for a majority, given the current makeup of the court. Let's see. How do Justice Thomas and Gorsuch square their textualist and originalist principles with the challenge to New York Times against Sullivan? The First Amendment says Congress shall make no law. And in light of what the First Amendment says, Sullivan makes a lot of sense. Well, the difficulty is, again, how you view original meaning. And this is a puzzle for originalists, something of a puzzle for originalists. Do you view original meaning by simply looking at the what you might call the linguistic content of the words of the First Amendment at the time it was adopted in 1791? Or do you look at the background against which the amendment was adopted, because that would inform the original public meaning? And there's a good argument that as adopted in 1791, defamation was not necessarily considered something that the First Amendment had much to say about. Defamation was a common law cause of action, and states at the time did not view a defamation action as necessarily presenting a free speech limitation. So that's the way you would square your originalist principles with questioning New York Times against Sullivan. The other is that Sullivan itself is not an originalist decision, because, of course, at that time, the originalism of today was not in vogue, and justices didn't take as their starting point a kind of historical investigation of the constitutional text and context. So it's not that difficult to see Gorsuch and Thomas ending up in a position of questioning Sullivan. And in fact, some of the other cases of the 60s, 70s, and 80s that find robust First Amendment protections for speech. Let's see. Maybe I'll close on this question. This is about the oral history of Justice Stevens that we took here at NYU as part of the Institute of Judicial Administration. Justice Stevens, who died in 2019, agreed to participate, and I interviewed him along with my colleague Sam Estreicher and Carol Lee, who was a former Stevens clerk. This is part of a larger project that we have launched here at NYU to take oral histories of American judges. And we've now interviewed a pretty large number of justices and judges on the lower courts as well. The Justice Stevens oral history was a joy for me because it gave me the opportunity to spend 3 long sessions with him, recounting his life. And I'll close by noting that on Monday, I will be at the Supreme Court for the traditional memorial for Justice Stevens. This is usually held the year after a justice dies, but a year after he died was the pandemic. So it's being held on Monday at the court, which will be sitting in a special session. And as part of that event, a resolution discussing the justice's jurisprudence and life is prepared. It's adopted by the court. It's published in the US reports. And much of that resolution was informed by the oral history. It was shared among those of us drafting it and was incredibly informative. So I'm very happy to have participated in that as a personal joy, but also as an academic endeavor that I think was very, very worthwhile. Okay, I think we are at time. Let me just close by thanking you all for participating today. I hope I've sparked lots of interest. Further conversations are definitely welcome. As you know, I've been designated as the next dean of the law school, and I really, really look forward to interacting with many of you this weekend at reunions and hereafter. So again, thank you and good day.